Every day in the USA, people find themselves in court.
All right, we will go on the record now in the 13th Judicial District, the District Court of Greenwood County, Kansas. This is case number 2023 TR3 00060, State of Kansas versus Isaiah S. Curvin. This is a continuance of the hearing called earlier on the 9 o'clock docket. It is now 1:36 p.m. this February 5th, 2024. Coming on for a special setting. Now then, Jill Gillette, County Attorney, appears for the state, and the defendant, Isaiah Curvin, appears in person and pro se. This is the pretrial hearing. The trial is set for jury Wednesday and Thursday of this week. February 7 and 8, there is one count of operating a motor vehicle without a valid license. Now, that seems to the court to be you either had a license or you didn't. Of course, the burden would be on the state to show there was no license, but Mr. Curvin, are you challenging that? Are you saying you did have a valid license?
No, I had a question before all that about the jurisdiction. I was challenging jurisdiction because I had a question about that.
Okay.
I wanted to know the cause and nature of what's bringing the suit against you. So I really didn't understand.
All right. Well, the people of Kansas, as you probably know, get together ever so often and have elections to elect people to represent them in Topeka, the state capital, and those legislators pass laws that are for the good of all of us in theory, maybe in practice, and then we are to follow those laws. One of the laws at some point in time that those legislators made was that if we are going to operate a motor vehicle in Kansas, we have to have a valid driver's license. And if you do not have a valid driver's license when driving the automobile, it is to be treated as a Class B non-person misdemeanor. And they set the penalties of up to 6 months in the county jail and a $1,000 fine. So the authority comes from the people of the state of Kansas that pass the laws through their elected representatives. And they also pass laws to have judges, and I'm one of those judges that presides over these type of cases. They also pass the law that you can't have a jury trial for this type of offense. And so that's the authority, that's the nature of it. It's a traffic case, but it's also designated a criminal case, a B misdemeanor. So does that help you with your question, sir, or is there something else we need to address?
Well, yes, I have another question. When you say it's been a criminal, would that it gives the court two ways? Sixth Amendment actually gives the court two ways to do it. They can do it through like either like common law or is it colorable maritime admiralty law? Which one am I want to be tried under? With jurisdiction?
This is neither common law nor admiralty law. This is criminal law under the Constitution of the state of Kansas, as affected by case law and federal law, of course.
So it's neither common nor color.
That is correct. That is correct.
So which one? What am I going to be tried under? What jurisdiction I fall under so I can properly move and so I can understand how to defend myself?
You're being tried under the criminal jurisdiction of the Kansas statutes.
But under the Constitution, it grants you only two, and it has two criminal matters. One has to be common law, the other has to be the maritime admiralty.
Ms. Gillette, do you wish to be heard in response? I'm sorry, I didn't mean to cut you out.
Judge, this is basically kind of more of a statutory violation. This defendant when you enter into the state of Kansas, you consent to the laws of Kansas when you drive upon the highways. The interstate compact between all of the states that are members of the interstate compact for traffic of infractions means that when you consent to the laws of your state, or you drive upon or travel upon the roads of Kansas, Oklahoma, any of the states that are part of the compact, you consent to those laws when you enter into that state. So with the interstate compact, he would be consenting to the laws of the state of Kansas the moment he drives across the border. That law becomes effectual upon you, and it's your responsibility. It's akin as when you have a concealed carry. If you carry in Kansas and you have your concealed carry, it's your responsibility to know which receiving reciprocative of your concealed carry permit. If that state isn't reciprocative, then you cannot do it within that state. So when you become a licensed driver, or you have a license, or you become a driver and you're driving, then you are consenting to the laws of that state that you are traveling within. So jurisdiction is set up, as the judge said, by the Constitution of the state of Kansas and the laws of the legislature that are passed statutorily, and our statutes are passed with the law in this case. I would note for the record, Judge, that there is still no things on Odyssey for me to see. There's not a written request for jury trial. There's no motions to be heard today. I cannot respond to any motions because there's none on file.
Well, that's
Therefore,
because I'm just asking questions right now.
if he is going to file anything of record for me to respond to, he would need to have his filings on file at least 7 days advance of a hearing for me to respond, and that there is no proper written request for a jury trial at this time. Therefore, this case could go to bench trial on Wednesday, and we would not have to have a jury present due to the fact that there is a lack of request for jury trial. And if there is no written request for jury trial, the case goes to bench trial.
Ms. Gillette, we just had this exact issue on not filing a demand for jury trial in a Butler County case right before the lunch hour. Mr. Patterson presented 19 Canap 2nd 982, State of Kansas versus Gardner L. Jones III. Jones raised two issues on appeal: whether the district court abused its discretion by denying his request for jury trial, and whether the district court erred in denying his motion for setting an appeal bond. Well, I have not had time to read that case over the lunch hour, which began at 1 o'clock today because we ran so late this morning. But Mr. Patterson, as an office of the court, informs me that in a case like this, even though the statute of Kansas is very clear that you are to put your demand for jury trial in writing, the case law says you don't have to because of your constitutional right.
I haven't had time to research it or read it, Judge. I don't have any kind of written request or motions, and I would have to take time to also read the case.
Sure.
And see if it's distinguished, if there's different issues. But he's wanting to argue jurisdiction, dismissal motions, and all kinds of motions. There's nothing before the court in writing for me to respond to. I don't know what he's going to say. So one of our other pro se individuals had written several motions. Most were very lacking, but at least I had something to respond to. In this case, under the laws and Constitution of Kansas, you submit when you come into our jurisdiction. Therefore, when he traveled into Kansas and operated a motor vehicle, he consented to the laws and jurisdiction of Kansas. And I would say that we have jurisdiction, and that lack of venue and jurisdiction is denied, should be denied.
I had a question about that because when you say that I consent, is there like a form? Is that what would that be under? That would be civil. Would that be
Sir,
like a
you,
would that be
you
the
can,
criminal matter?
you consented by your conduct of going on to a road that is a state of Kansas highway and a,
So which jurisdiction would that would be under? Like, would that be like maritime, like as a like a
sir,
contract?
I've answered that question to you. And you got on the road and you consented to driving on the road, and therefore you did consent
I
to the
understand that.
laws associated with driving. So I am going to hold you to the law in this
I understand that.
particular case. Now,
What I'm understanding when you say like when you said the cause of nature, and but that's why I was not understanding still about that because you said the cause of nature. And I then I asked
sir, if you want me to entertain any of your arguments, you need to have them well thought out, and you need to have them
That's
in
what happened.
writing, and
That's
you
what the
need to
special
have them,
appearance is for.
sir, listen to me, please. You need to have them in writing. You know, need to have them filed with the court. You need to give copies and notice to Miss Gillette so she can have an opportunity to respond. And I'm not going to entertain this process throughout the proceedings where you come in and you just start saying things.
I have a question.
Things
That's
that
why
you
I'm
may have
asking.
picked up here or there on the internet or by other people. I don't know where you get some of this stuff, but it is very common for people, certain individuals, to come in and start repeating some of this stuff that so far I haven't heard anything that has merit. These arguments of, well, you're either maritime or you're common law. That's not going to carry weight with me. You're going to have to give me something that tells me I have to follow those arguments, because I think you're misstating the law. So
No,
by
well,
now,
maybe
you should have had all your motions on file. We're
yeah,
ready to
maybe you misunderstood
start.
what
Sir,
I was
please don't
asking.
interrupt to me.
That's I had a question
Sir,
when you're done.
stop and listen to me. If you want a jury trial, I will make sure you have a jury trial. If you want to
Before I get to that, I
represent,
had questions.
sir,
That's what I'm saying.
stop.
I have
Stop
before that.
interrupting me. If you want a jury trial, I will make sure you have a jury trial. If you want an attorney, I'll make sure you have an attorney to help you. But if you're going to do this on your own, you need to know what you're doing, and you need to follow the law just as an attorney would be expected to. But you're not going to come in here and just start saying things, and I'll answer questions as long as they're legitimate questions. So at this point, I'll ask you once again, are you sure you don't want an attorney to help you, someone who is trained in the law? Because this, sir, is a court of law. And if you don't have the benefit of knowing the law, you're going to be disadvantaged.
Well, before I move forward, I had questions before I move forward. That's why I was asking to understand it. Cause I often understand this.
Well, I can't aid you in the unauthorized practice of law. I cannot.
No, I'm not asking. I'm not asking for legal advice. I'm asking for your legal intent. What am I going to? What do you intend to be trying me with jurisdiction? That's why I'm asking if it's under which one. And you said it's a criminal matter. If it's criminal, then
Sir,
there's someone's been hurt. So if there's someone's been hurt, I have the right to cross-examine.
I have answered your question legally, and you keep trying to give me limited illegal choices, and I'm not going to do that.
Under the Sixth Amendment,
You
I have
can
the right to
renew.
know. Under the Sixth Amendment, I have the right to know what jury I'm going to be tried against, and you have the duty to tell me. I don't think you're going to be violating your oath to office if you did that.
I've answered those questions, sir. We need to move on. I've made it clear to you, it's a couple of hearings now that you're being tried in the District Court of Greenwood County, Kansas,
Well,
under the laws of the state of Kansas. And we're not going to keep running in circles on this.
that is not.
You know
I'm
this,
saying
and I know this, and I feel like you're just kind of.
No, what I'm asking, so the court only, the Constitution only grants the court under when it comes to criminal under two matters, and that's why I asked you: is it civil? Is it civil or is it criminal? what you said is criminal. It said it's not civil, right?
Sir, you can reserve your right for appeal, but I have ruled. Now, what's your next question or your next point of view? And I need to have you back here. Bring your camera back so I can see you.
Your phone froze. I didn't hear what you said. Your phone froze. You froze.
I don't know if my phone froze or your deal.
Oh, mine, yeah, my phone froze. You cut out for a second.
Okay, so do you want an attorney? I'll ask you that again.
Before I get to that, I still have to find out. I have the Sixth Amendment right to know. If I ask, I have the right to know. I'm not asking for legal advice. I'm asking for your legal intent.
Do you want a jury trial and do you want a lawyer? Those are the two things you
Before I
need
get to that, I
to
have to understand what jurisdiction I'm under, so I can rightfully, so I can know how to defend myself.
Okay,
Now.
you don't like
You're not,
my
you don't,
ruling.
you don't. So I had to. So are you telling me I have to get a lawyer to understand? For the record, you just have to get a lawyer to find out what I'm going to be tried against. Is that just some type of secret jurisdiction that I shouldn't know
Okay.
about?
Okay, sir, here's the deal. You're either, I'm not gonna play games with you.
I'm
I
not. I'm asking. I'm asking
understand,
because
I
I have the right to defend
understand the
myself.
sovereign citizen uh, position that you
I'm
take.
not claiming. I didn't say anything about sovereign anything, ma'am. I'm
When
asking. I
you're
have the
sure
right to
making
defend
their
myself
arguments, you're sure making,
under my Sixth Amendment right to know. I have right to know which jurisdiction are you going to try me under, and you're telling me in order to ask me for a lawyer, and I'm like before I even go to trial, I like to know what jurisdiction am I falling up under, and you're telling me how to find in order to find out I have to get a lawyer. So you're telling me for the record, the defendant has to get a lawyer because there's only some way only lawyers understand what jurisdiction or what I'm going to be tried under. So that's the only way I can know. Instead of you asking me, but you have the duty to tell me under the Sixth Amendment. Do you not?
okay, now it's your turn to stop talking and my turn to talk. I have answered your questions. I've told you the jurisdiction. You don't like my answers, so you voice your objection for appeal and we move on. We're not
No,
going to
no.
keep playing this game, sir. Now, do you want a lawyer or do you not?
I should not need a lawyer for you to tell me. And when I'm asking you, like, because you saying it's not a criminal matter, so there's a hurt party. So
Sir, quit repeating yourself.
if there's a hurt party, can you present the hurt party to me?
If you keep sitting here wanting to argue with the court, I may have to find you in contempt. Is that what you're trying to get
I'm
me
not
to?
arguing about the court. I'm trying to understand. I'm
If
still not
I
understanding
cannot, I cannot educate you and train you
I'm not
on
asking for
law.
educate because
If you
you're
want to rip, sir, do you know there's a person that's going to try to type out this transcript? And if you keep talking over me, do you know what chaos you're going to cause for that transcriptionist? We have to take turns talking. I've answered your question repeatedly. Let's move on to the next question. Or the next point. You don't have any motions I can rule on because you don't have anything in the file. So are you going to hire an attorney, apply for court appointed, or continue on your waiver?
So if you're gonna try one, is there someone that was hurt to make a criminal matter? I like to know who it was.
Are you going to hire an attorney, apply for
I'm
court appointed, or continue to waive your right and represent yourself? Keeping in mind, sir, if you waive your right to an attorney, you will be held to the same standards as a defendant with an attorney. You will be held to the same standards as the attorney. You need to know the same rules, procedures, and laws. So can you not understand what I'm saying?
You asked me if I want a lawyer. If I want a lawyer, I'm not moving forward because I'm not understanding where we're still going under here. Where you're telling me like it's on the criminal matter. If it's on the criminal, if it makes a criminal matter, that means it has to be like some injured party. Where is injured party at?
I'm going to order that you appear at the courthouse. Where are you parked right now?
I'm in Texas.
You do know your trial is Wednesday and you have to physically be present in the courthouse. It is not a
Before
Zoom.
we get to trial, I'm trying to figure out the jurisdiction. You just haven't went over to what the jurisdiction is.
Well, if you don't want to submit to the Kansas jurisdiction for your live trial on Wednesday, I can get you a warrant and you can be brought before the court.
I'm appearing in person right now. I'm doing my duty to appear, but you're not
We're
telling
not
me.
having a Zoom jury trial.
They're not telling me. You're not telling me what. You're not even telling me what the nature of the cause. You're not telling me. You're not even telling me if it's common law. If it's common law, then you telling me that it's a criminal. If it's criminal, then there should be an injured party. I'm asking, where's the injured party? Can you bring the injured party forward?
I am going to, Missy, do you know where Miss Gillette went?
I don't, Judge. I'm assuming she lost signal.
So, are you not going to tell me this record date? You have the right to know.
You want to try
Excuse me,
to,
Your Honor.
do you want to try to see if you can find her for me, Missy?
I think when she gets signal, she'll be back.
Okay, well, we're going to be in recess till Miss Gillette gets her signal and gets back here, because I'm not going to do anything without both parties present. So we're going to go into recess.
Sorry, Judge, my phone screwed up.
Well, apparently the defendants did too, so I'm gonna give him a few minutes to see if he comes back.
Everything went out and I couldn't get back on at all.
There he is. All right. We are back on the record in the 13th Judicial District, the District Court of Greenwood County, Kansas. Case 2023 TR 300060. State of Kansas versus Isaiah S. Curvin. Parties as before. Mr. Curvin, you are set for jury trial.
But before we even get to trial, man, you still haven't answered my questions. I still want to know
Wednesday,
the cause of nature
November.
of the matter.
Sir, I'm gonna find you in contempt if you keep talking over me and being disrespectful.
Ma'am, you keep not even answering my question before we
All
get to jury
right,
trial. You're just
okay.
setting it.
You are now found in contempt.
That's it.
We will deal with your consequences Wednesday at the jury trial. This is set for jury trial. It's going to cost the taxpayers some money, so you better make sure you're ready to go to jury trial come Wednesday. You better make sure you're not in Texas. You better make sure you're sitting in the courtroom in Greenwood County, Kansas. That's Eureka, Kansas. Do you understand, sir? Any questions
Ma'am,
about?
I don't. No, I still have questions that was never answered.
I'm not your attorney, sir. I'm your judge.
Yeah, I know you're not returning. I'm asking you, Judge. I'm asking for legal violation. I asked you what was your legal intent. You still haven't told me what your legal intent. I asked you what was the nature and cause of this.
My legal intent is to conduct a jury trial on you Wednesday with the jury.
And what was the nature and cause of this whole before all that? What was
The
your nature and cause?
nature of this charge is that you were allegedly operating a motor vehicle without a license in Greenwood County, Kansas, November 9th, 2023. That's the nature. Now,
And you said it's,
I'm not-
and I asked.
we're not doing this.
I said a question. So when I asked you what jurisdiction the court, the Constitution grants the courts the two jurisdictions, which one is common law, and the other one is maritime admiralty law. You said it's neither one of them.
Sir, you better go back to law school because I don't think you got the education you need to represent yourself. You either need to go back to law school or go to law school or get an attorney, sir, because you don't understand that which you're speaking of. So be ready to go. And if you're not here and ready to go, Wednesday, I will issue a warrant for your arrest.
Your Honor, I still have a question. You still haven't answered my question before you dismiss. I
And
asked
I
you which
told
law
you, sir, I am not.
under the Sixth Amendment, right? Under the Sixth Amendment, you have the
Okay, I'm gonna fine you. I'm only gonna fine you $50 for that first contempt.
$50 for what?
For continuing to ask the same questions over and over after.
I'm asking it. You never answered it. You never told me.
I'm going to object. It's been asked and answered. It's been ruled on, Judge. We need to proceed to the next step. The state has taken the opportunity to glance through the case Mr. Patterson cited. It can be distinguished from this case because the ruling says the person has to be subjected to up to 12 months imprisonment. It is a DUI case where someone was convicted of a first-time DUI and they were subject to 12 months of prison time or jail time under the law. This is a Class B non-person misdemeanor that's 6 months or less. It must be greater than 6 months in order for the person to be subject to an automatic jury trial. Otherwise, lacking the request It may be a trial to the bench under the case law. So therefore, the State v. Jones did not apply in this matter. He is facing no more than up to 6 months. So the automatic requirement for jury trial does not apply in this case to Mr. Curvin. The request for jury trial would still need to be in writing for a matter that's up to 6 months. And therefore, I would ask that we don't waste a jury's time and have a bench trial on Wednesday. And move forward in the case.
Mr. Curvin, do you want a jury trial or a bench trial?
I want a jury trial.
Understand, I'm not going to prejudge, but I'll strike that. That wouldn't be appropriate. Let's see, do we have tomorrow open? Let's see, we've got a 9 o'clock docket. What do we have going on tomorrow afternoon, Missy?
We have first appearances, and I haven't looked at them yet. And then,
Okay, and then we have 3:30.
yeah, we have a couple at 3:30, and then we have a 4 o'clock case.
Ms. Gillette, can I continue this for further pretrial hearing with the live hearing, defendant present tomorrow at, what do you have? Can you fit me in at what, 2:30, Missy? Do you have time then? Pick me a time. Give me about a half an hour tomorrow that you can fit me
I
in.
think our 11 o'clock went off. Let me.
I was going to say
Are you saying I have
11 o'clock is the perfect time for the state judge.
Well, but I've got to give Mr. Curvin, I've got to give, sir, please quit interrupting. This is not a free-for-all. Miss Gillette, we've got to give him time to drive up from Texas.
Yeah.
Well, if he doesn't have a license, he can't drive. We have to give him time to find someone who can drive him up here, or give him time for a plane ticket, or however he wants to get here.
1 o'clock p.m. from 1 to 1:30. Then we can start the first appearance docket at 1:30.
Sounds good. Okay. Sir, this is going to be a live pretrial hearing tomorrow at 1 p.m. You must be
I cannot make it tomorrow, ma'am. I'm in Texas. That's what I was trying to tell you from before.
Well,
You told me you said Wednesday at first, and now you're saying tomorrow.
Well, your jury trial is Wednesday. Your pretrial is continued to 1 p.m. tomorrow. There is no law that says I have to give you a Zoom hearing. I try to do that as a courtesy.
I could do the Zoom, but I wouldn't be able to drive because this where I'm at, like I'm already like right here by San Antonio. It's like about a 14-hour drive. Like even if I drove right now, I would still wouldn't make it to probably 2, and I would drive just like 32, 14. That's like half the day driving. Now I don't have nobody to drive like that. You know, man. Like that's why
if you don't have a license, you better not be driving, because then that'll be another violation of the law. But that's my order. Be here at 1 o'clock tomorrow, live and in person. If you're not here, then most likely a warrant would issue for your arrest, and we'd go from there.
Well, I'm telling you, if I wouldn't make it, what's my other option? If I'm already in Texas, not to, that's hours away. You know, it's like about 4 different states.
Well, sir, you came to Kansas. You violated the laws allegedly in Kansas, and you've taken up a lot of the court and counsel's time. So,
well, I was told the officer said he told me I can take care of it from Texas. I would have to come back to Kansas when I got the rest of the ticket.
I have always told you that the trial would be live. Don't be pulling that on me.
No, not you. I'm talking about the officer when I got the ticket. When I first got it, I let him know I was just coming through Kansas. You don't live here. He said she said normally it's to do video and stuff because it's still different state.
Normally it is, but I'm ordering that you be here in person tomorrow at 1 o'clock. And anything further, Miss Gillette?
Nothing at this time.
Hold on, my phone cut out. Hold on. So,
Mr. Curvin?
say it again, ma'am.
Any motions you want to take up tomorrow at the pretrial, you better have them filed by 5 o'clock tonight with copies served on the prosecutor, or I'm not going to entertain them tomorrow. You've had a long time to get those on file, and you haven't done it. And I'm through with repeating myself over and over. So at this time, You owe the court $50 for contempt. We'll address that tomorrow as well. Okay, we'll begin recess.
I have a
Thank you,
question
Judge.
before we go. When you said the when you said like how to file the motions and everything, did you receive my special appearance motion or anything like that?
Nope. No, sir.
You hadn't received it from last time?
Nope.
I filed that before.
No, sir. I don't know what you're doing with them, but we're not getting them here.
I was told that you had received them through email, or I sent the email
Okay,
to I sent it a few
sir.
times. Not like that was the only way.
If you can't figure out how to do it on your own, then you need an attorney. And I have told you repeatedly that if you cannot afford an attorney, you can
No, they
apply,
told me
and I will appoint one.
they told me they had received them before. That's why I was understanding. Like you say you never received them, but you say you received them before. Like the first time we appeared, and then I actually haven't received them. I haven't called.
Just because you keep repeating something doesn't mean you're going to get a different result.
No, I haven't repeated. I'm asking like they never received it, but they told me they did. That's just
You keep saying the things over and over, thinking like you're going to get a different result, and the answer is going to be the same every time.
Okay. You have a good day, y'all.
Thank you, sir. We are adjourned.